welcome to this online policy dialogue organized by the European Policy Center to discuss the European Commission's first rule of law report published last week. As you all know, the European Commission, as recognized by the Court of Justice of the European Union, is responsible for guaranteeing the respect of the rule of law as a fundamental value enshrined in the EU's treaties, and for making sure that EU law values and principles are upheld. In that capacity, over the past years and in response to a growing number of violations of the rule of law, fundamental rights and civil liberties across the EU, the European Commission set out to expand the toolkit at its disposal to prevent and respond to democratic backsliding in the member states. To existing instruments such as the EU Justice Scoreboard, the European Semester, the Cooperation and Verification Mechanism, the EU Rule of Law Mechanism, and so on, the Commission has now added on the 30th of September also the first ever annual report on the state of the rule of law EU-wide. This latest initiative is part of an ongoing effort on the part of the Commission to better promote and defend democracy, and which foresees that still by the end of this year, the Commission will also present a new strategy for the application of the new Charter for Fundamental Rights and an EU Democracy Action Plan. I'm sure we will hear more about all these plans from our speakers, but I wanted to underscore that this report, which makes the focus of our discussion here today, is part of a broader continuous work by the European Commission, whose ambitions are also shared by other EU institutions and stakeholders. Having said that, the intention today is to concentrate on the rule of law report, to understand its findings and implications, and to gauge its precise role and utility now, but also in the future. To that end, I'm delighted to introduce to you our accomplished speakers today, including Didier Reynders, European Commissioner for Justice, Katalin, Cseh, Member of the European Parliament for the Renew Europe Group, and Daniel Kelemen, Professor of Political Science and Law, and Jean Monnet Chair in European Union Politics at Rutgers University. Thank you all very much for accepting our invitation. We will first hear from the panel, and then everyone in the audience will have the chance and will be encouraged to ask questions and make comments live or in written as you prefer. Now, I would like to start from the Commissioner, kindly asking him to walk us through the report and to tell us what are the key messages we should take away and remember. Commissioner, the floor is yours.
Thank you very much, and thank you for the presentation and this opportunity to speak online about the first annual report on the rule of law that we have adopted at the Commission level last week. And I believe that maybe most of you have already had the opportunity to read the report, and maybe to read not only the general part, the communication, but also the country-specific part, at least for one member state, or if it's possible for the 27. And so I don't want to go into details, but I want to maybe underline a couple of elements before we start the discussion with the panel and the audience. First of all, the report. The publication of the report is, of course, an important moment for the Union. I said it's the first time that the Union has undertaken a systematic reflection on the state of the rule of law in all the member states. I insist on this, and it's a valuable source of information. Will be useful for future discussions. And of course, it will help to launch a new stage in the protection of the rule of law, but also in the promotion of a culture of the rule of law in the Union and in all the member states. I've always mentioned it, that the rule of law should be examined in a comprehensive and continuous manner. And this is an ambition that I have always defended, particularly in my previous function, was I was sitting in the Geneva Council on the other side as member of a government. Since 2016, I have asked to have a real peer review on the rule of law at the EU level. And I have always been one of those who believe that we should not limit ourselves to examining only certain countries, but rather that we should look at all member states on an equal footing using a common and objective methodology. With the rule of law report, this is precisely what we have done. And I must say that is only the start of the process. We will have, of course, other reports and many discussions. What is the rule of law mechanism? In fact, with the annual report on the rule of law and the center of the mechanism. Of course, our report covers both positive and negative developments in the Union, including a neutral and balanced country-specific assessment of all the 27. And the rule of law mechanism with the rule of law report at its core will serve to deepen dialogue and joint awareness on the rule of law throughout the Union. And the mechanism is a yearly process during which we aim to prevent problems from emerging sometimes or even deepening in some member states. It is a new tool which comes in addition to other instruments that we have to protect the rule of law in the Union. So we don't replace other tools, we have an additional one. To set up the mechanism and to set up also the report, in January, I wrote to all the ministers for European affairs, inviting them to establish a network of national contact points. And this was instrumental not only as a constant channel of communication with the member states, but also to discuss the methodology of the report. So it was a real discussion of the framework of the report with the member states. On this basis, all the member states provided written input, but we also carry out a targeted stakeholder consultation with a questionnaire where over 200 stakeholders provided written input. We also conducted, due to the COVID-19, not physical country visit, but 300 virtual country visits by video. Last but not least, every member state had the opportunity to check its own draft country chapter at the end of the process for factual accuracy. All the member states have been treated equally, and we apply the same methodology to all and constantly ensure consistency. We also kept the Parliament informed of the progress in the preparation of the report, and we made sure that this process was robust, transparent, and as inclusive as possible. But let me also be clear that this report represents the Commission's own assessment. It's not a joint assessment between the Commission and the Member States. It's an assessment from the Commission. But now, I understand that you are familiar with its content and the main findings, so I want not to be too long, but in essence, the report again provides a qualitative assessment of 4 key areas: the independence, quality, and the efficiency of justice systems, the anti-corruption framework, media pluralism and media freedom, and other institutional checks and balances. On the independence, quality, and efficiency of justice system, we noticed that a number of member states efforts are underway to strengthen judicial independence and reduce the influence of the executive or legislative powers over the judiciary. But we still have concerns, sometimes structural, for some member states. In terms of quality of justice, the current pandemic has highlighted the importance to accelerate the digitalization of justice. And I'm happy to witness a real improvement and the share of good practices in such a way. In the second area of analysis, we note that several member states have recently adopted comprehensive new anti-corruption strategies or revised existing ones. What will, however, be key is that their strategies are effectively implemented and monitored to ensure that progress is made on the ground. Thirdly, on media pluralism and media freedom, we came across worrying signs in some member states with regard to the political influence on the media, a lack of transparency when it comes to media ownership, and risks to journalists and other media actors. We have seen already some murders, you know that, but we have seen also some other attacks, and so injustice, with many actions in justice against some journalists and certain investigative journalists. So the so-called slaps, it's a real concern about the way to attack different journalists and media actors. On the positive side, there is a healthy debate on strengthening legal and constitutional safeguards in some member states about the checks and balances, the final chapter of our report. But we also know that reform processes are underway. However, we also identified a number of rule of law related concerns in this area on the checks and balances, In a few member states, we see repeated recourse to expedited legislation in parliament or emergency ordinances from the government. Moreover, in some member states, civil society lacks an enabling framework, faces a diminishing space to operate, legislation that limit access to foreign funding or smear campaign, to name but a few examples. And maybe some words about the next step before the conclusion. Where do we go from here? The comprehensive European rule of law mechanism is more than the report itself, I said. What we want to achieve through this report is a true dialogue at the EU and at national level with the European Parliament, the Council, national parliament, as well as European and national stakeholders. This dialogue is so part of the mechanism, and we want to promote the rule of law across the EU. We have a unique source of information now that we need to make the best use of it. I was already in the Libe committee in the Parliament and in the plenary of the European Parliament to present the report and intend to continue the joint work with this institution. I also intend to discuss with national parliaments, and I've started the process to go to different national parliaments. Another discussion will take place in the Council. The German presidency intends to organize 2 discussions in the General Affairs Council, a horizontal discussion covering general rule of law development in October, the 13th, next week, and country-specific discussions addressing key developments in specific member states in November. We will start with 5 member states: Belgium, Bulgaria, Czech Republic, Denmark, and Estonia. I also called on civil society and relevant stakeholders to discuss this report and provide us with their feedback. Of course, this will feed into next year's rule of law report. And to conclude, let me assure you that this is our mission to bring this mechanism to life so that it becomes a foundation for the protection of the rule of law in the Union. This being said, I would also like to underline that this new instrument will not replace the other instruments of our rule of law toolbox, such as infringement proceedings. We have received again today a positive reaction from the Court of Justice about 1 infringement proceeding against Hungary before the Court of Justice, the Article 7 procedure, and the European semester with some specific recommendations in line with the rule of law. On the contrary, these different instruments are complementing and reinforcing each other, and will take them together, allow us to better protect the rule of law. And so I thank you, of course, for this invitation. I want just to say that we try also to have new additional tools. And you know that there's a real discussion about the conditionality between the rule of law and the funding of the MFF and the Next Generation EU. So in fact, the funding of different policies. But I'm open to discuss on this maybe with the panelists, because that's a new step to have a new instrument later. And so thank you very much for your attention. I'm very pleased to discuss with the panelists and with maybe the audience. And I will hear you if you have.
Yeah. Sorry, I was muted. Thank you very much, Commissioner, for your presentation. To quickly follow up, it is important that we now have this inventory of the rule of law in all member states, and we can see that actually no country gets a clean bill of health from the Commission. There are issues everywhere, some significantly more challenging, let's say, than others. Yet the report essentially stops there, and short of making recommendations on how to deal with the problems identified. As such, can it still make a difference on the subject and become, as you called it now, a foundation for the protection of the rule of law in the EU?
Maybe 3 remarks in answer very briefly. First, there's nothing new in the report. If you are a specialist about one of the 4 chapters in one of the 27 member states, normally you know the situation, because we have just a global picture, but it's a real collection of all the data at our disposal coming from the member state and all the stakeholders. So it's not new, and with occurrence in relation with the previous declarations and communication from the Commission. The second element, we don't have a recommendation, is true, but we have very clear indication about the best practices or the situation where we need to receive a positive answer from the member states to have an improvement. And so why? Because we are not sure, in fact, that we have a legal basis to come with real recommendations. So we come with a report, but of course with very clear message, and it will be the base of our monitoring, maybe to go to infringement proceedings, maybe to go to other procedures. But the third element is that if you read the report and certainly the country chapters, you will see that there is a huge difference. In many member states, I will say in all, we have concerns about the rule of law. We have concerns on specific issues, and it's possible to engage a dialogue and to try to improve the situation. But in some, we have more a systemic problem, and we have more a systemic violation of the rule of law in our minds. Is the reason why, just to give an example, we are before the Court of Justice about different elements in Poland, in our views, against the independence of the judiciary. Is the reason why we have started infringement proceedings. We have asked interim measures to stop the disciplinary procedures against judges. And so there it's more a systemic issue. But it's not new, because we have two Article 7 procedures, one launched by the Commission against Poland, one launched by the Parliament about Hungary. So that means that there are some concerns for a more systemic problem with the rule of law. So that's the main element that we have in the report.
Okay, and then if I can press you a little bit more on this methodology question. Some member states have claimed that actually the report cannot serve as a basis for any rule of law debate in the EU because its methodology is supposedly flawed and the sources that have been used are biased. And so it was interesting to hear from you today that you actually have consulted each country about its own chapter, and so I would have assumed that there was the green light before the report came out. So how do we explain this criticism, and also to couple this with a question that I'm seeing from our participants already, someone from Democracy Reporting International asking what improvements to the methodology of the reports would you introduce in the next cycle?
But that we will discuss, of course. We are at the beginning of the discussion on the first annual report, so I'm very open to receive remarks and observations and proposals to change the way. But about the methodology, it's very important first to repeat that we agree on the methodology and the framework of the report with all the member states. From the beginning, we have had a first meeting in February with all the contact persons from all the member states. And then we have asked to give an answer to a questionnaire to the member state, but also I said many stakeholders, more than 200. We have organized country visit with the authorities in the different member states, and of course with European organizations, NGOs, and national organizations and NGOs, associations of judges, lawyers, and so on. And we have worked with institutions like the Council of Europe or FRA, the Fundamental Rights Agency in Vienna. But at the end, it was again possible for all the member states to react on the last draft of the report. And just that to say that we have received a very good collaboration from all the member states, all. I insist on this, with some remarks from one member state about the methodology at the end. But of course now, what is very visible? We have a positive reaction in the Parliament, as I said, in the Libe committee, in the plenary, and there's a positive reaction about the content of the report. And now it's possible to start the debate. It's true that there are maybe two member states with another approach. It's true also that we have adopted the report in the Commission with two objections in the Commission. So, but it's a report from the Commission, but we are knowing that we have different views. But about the methodology, it's not correct, because it was not by surprise that we were coming out with the report. The member states were at work since the beginning of this year on all the different chapters and on all the different elements. But now we are very open to engage the debate, and I said we'll do that in the General Affairs Council with the member states, also about the country chapters, country by country, member state by member state. And I've said to the Parliament, I'm open to go to the European Parliament to discuss not only like we have organized in the plenary in Libe in general, the report, but also country by country. And more than that, of course, I'm open to go to all the national parliaments to do the same with the majority, the ruling parties and the opposition, but also with the civil society. So again, it's a first debate about the methodology because we're very, very clear on the methodology with the member states. But of course, there is a different appreciations about the rule of law. We are knowing that. And I was pleased to see that 2 member states decided to install a new institute about the rule of law. It will be interesting to discuss about the conclusion of such an institute in some months or in 1 or 2 years.
Okay, thank you, Commissioner. I'd like now to turn to Ms. Cseh. Today, the EP has tabled some, if I understood correctly, some final amendments to its own resolution on the rule of law, and it will vote on it tomorrow, if I read correctly on the EP's website. How is this initiative from the Parliament on the rule of law different from the Commission's report, and why such disjointed efforts on the same topic among different institutions?
Maybe I may say some words about that before to go to the Parliament.
Oh,
because
okay.
Sure. Because I know Mrs. Cseh, we have discussed again in the Parliament, but we have started at the same moment in 2016. I was in another capacity as member of the General Council, and I've asked to a peer review at the Council level. At the same moment, some Parliament members have asked to organize a process with a report. And I know that there is a request to have an interinstitutional agreement to discuss on the rule of law, the democracy, the fundamental rights. What was the decision of the Commission in 2019 with a communication is to start with a mechanism about the rule of law. Of course, we are very open to go to the Parliament with the first report and the next report, but also if it's needed to join next year, not only the discussion about the annual report on the rule of law, but the report on the about the Charter of Fundamental Rights, maybe the Democracy Action Plan and so on. But we want to start. That's the main issue. Of course, if it's possible to have an interinstitutional agreement, it will be fine, but it's time to have a real first report on the rule of law and to discuss on this and to debate, and of course to improve the situation. Sorry to say that on the point of view of the Commission, maybe and in the past, but of course it's the last word is all the time to the Parliament.
Excellent. Well, it's good to know your opinion on this. Ms. Cseh, you have the floor now.
Thank you very much, and thank you very much, Commissioner, for your insights and also for the very good effort. I think that was done on the first annual reporting. And if I may address the original question, I believe that these shared efforts that are coming from different institutions, but pointing into the same direction, are motivated by the joint effort we all share about strengthening the rule of law within our union, and also to provide a framework within which this can be implemented also when it comes to our legislation, our budgeting, and our daily lives. Just a very short addition. Before coming to this meeting, I was in a hearing with Commissioner Varheyev talking about the enlargement criteria, and parts of which concern the rule of law in countries who intend to join the European Union. So, and for me, this always warrants the question, and I believe I'm not alone with this, that why cannot we monitor and why cannot we keep checks in the rule of law systems of countries who are already members? And for this comprehensive report is a very good first step, because I believe we are right now witnessing a very strong democratic backsliding within our union, and these changes really happen faster than could be imagined. I'm a Hungarian, and my country does not comply with the Copenhagen criteria since 2011, I believe. We are the first country to be classified as not a democracy anymore by Freedom House. And this happened while under the watch of the European Union. And this is not only about Hungary. And this is also one of the benefits of this report, that it really covers everything. I have some slight criticism also when it comes to the emphasis certain things get compared to other things, but I do believe it's very important to have a comprehensive review of every country. And this also the scope of the Commission's report and the Parliament's reporting as well. Now, I think this is a good starting point, but we need to move forward. And as the Commissioner mentioned, we need to further develop our toolkit, but we also have to use our existing toolkit better. So this is what I always try to press, that we have a clause in every single EU funding program. There is a provision that this project has to comply with certain EU values, yet we barely use it. I think it was a very good first step when Polish cities who declared themselves as LGBT-free zones were cut from EU funding. So this begs the question, why cannot we use this instrument more? Or infringement procedures, pending ones should be concluded and new ones could be opened, and maybe a bit faster than before, because we received the CEU ruling today, 3 years after the bill happened, and the Central European University that was forced out of Hungary by political motivation has already have a new campus opened up in Vienna. So, okay, that's an important case law, but in practicality, it's rather limited. So if I just may take the time for very quickly address, I think the biggest debates right now, the question around the conditionality when it comes to our financial frameworks, I think this is really the fight of the moment. And Parliament is really shouldering responsibility that the Council tries to avoid. And this is why it's so necessary to have a dialogue with Commission and with voters, because we represent 500 million people. And I do believe that we have to guard the taxpayers' money of these people and also the rights we want them to share much better. This Parliament is very determined to have a strong rule of law process that is very much based on the report of the Commission, and also complemented with an independent panel of experts, because I believe that this is also a good way forward. We need to have reverse qualified majority so that the Commission's proposal is what is the basis, because this is the professional, it's not a political opinion, it's an expert opinion. We don't want politicians deciding between each other, heads of states before elections, where to put the emphasis and where not, and who is our friend and who not. Rule of law is objective, and it should be treated as such. So this is the second criteria of Parliament. And the third one, where we have a very good proposition from Renew Europe, the smart conditionality proposal, I'm advertising it here to the Commissioner as well, is how to safeguard the final beneficiaries. Because and I want to close on this note, because we are talking about infringement of the rule of law in countries, and we are talking about leaders who are not being democratic, but they do not represent the entirety of their country. And we have to acknowledge that the majority of Hungarian, Polish, or like any people in our union just want to live in a free, safe, and in European way of life. They are not the ones who are committing the crime, so they should not be penalized for that. That's why we need to protect the final beneficiaries and to use this framework to ensure the protection of the rule of law in the entire community of the union. We are hopefully, I hope that we are right on time, but this report is coming in a critical moment.
Excellent, excellent. Thank you very much. To bring in the some of the questions from the public, because we heard from the Parliament, Commissioner, I'm reading a question from Marcos Vart, asking, what's the Commission's take on the EU mechanism on democracy, the rule of law and fundamental rights to be adopted by the European Parliament tomorrow? Will the Commission include more aspects of Article 2 in its annual monitoring report, for example, minority rights in the member states?
The first idea about the rule of law report was to discuss about the independence, the quality, and the efficiency of the justice system. Because if you want to have a society ruled by the law, you need to be sure that it's possible for everybody, the citizens, but also the authorities, also the businesses, to go to justice, to ask if the law is in line with some principles, Article 2 of the treaty, but also the case law of the European Court of Justice and European Court for Human Rights also, and if it's possible to have a correct application of the law. And so that's the main issue. We have extended the report to the fight against corruption, media pluralism, checks and balances. It's possible to be open to go further than that, but I repeat, we'll have also a report next year about the Charter of Fundamental Rights. It's a specific, and the minority rights, of course, it's a part of it. We will have also a democracy action plan about the democracy and the evolution of the democracy. But again, the first element was the rule of law. And I want to add maybe just some points after I agree with the main remarks of coming from the parliament. But first of all, if we are doing that, it's just to, because I know that there were some hearings today, it's just to show that we are doing the job at home. So if we are doing the job at home, it's possible to do the same with the candidate countries, with the partners in the Eastern Partnership, Southern Partnership, or in the future partnership with Africa. We'll be stronger and we'll have more credibility to discuss on the rule of law with the different partners if we are doing the job at home like we are doing now. The second element I want to say is a timeline. Of course, we don't have exactly the timeline in the Commission that maybe in some speech in the Parliament, and certainly not the same timeline than on Twitter. When you need to go to the court, you need to have a robust analysis. In the procedure, that's the rule of law. You need to send a letter to the member states to receive an answer and then to go back to the court. And we are doing that, and we will continue to do that. Today, we have had a positive decision of the court about a law in Hungary about education and the universities from foreign countries. And it's very important to show that we try to have a robust argumentation. But if there are some risk on individuals, it's possible to go faster. We went to the court in February to ask interim measures about the disciplinary procedures in Poland. And in April, so after 2 months, we received a positive answer with a suspension of the different procedures about the judges in Poland. And if it's not correctly applied, it will be possible to go back to the court to ask maybe some fines in such a field. So we are working on it. And maybe the two last points about the conditionality. I agree with the remarks because, of course, it's the proposal of the Commission and it's on the table since 2018. So we ask a reverse qualified majority, we ask a large scope, and we are not against an expert panel to say something about the rule of law. But again, the report, it's an assessment from the Commission. And the Commission is the guardian of the treaties. So it's very important that we are coming with our report. After that, if the Council or the Parliament asks also to some expert to say something, why not? But we want to continue to work with our own assessment in the Commission because we are in charge of the treaties. And that's the way forward. But again, we are very open to discuss on individual rights and minority rights in line with the Charter. And it's true that it was possible already now to take some financial decisions. We have seen that for the LGBTI plus free zones in some municipalities in Poland, it was possible for a European agency to stop the funding of some twinning between those municipalities and other municipalities in Europe. Because of course it's a discrimination to say that we want to have LGBTI free zone against a minority in the population. So it's possible to do something on the basis of the Charter, but of course we have to do more with a real conditionality between the funding of policies and the rule of law.
Thank you, Commissioner. Professor Kelemen, you have come out with an op-ed today arguing that autocracy cannot be defeated with toothless reports, to use your words more or less. I take it that you do not think that the Commission's report can deliver in the defense of the rule of law in the EU.
Thank you. Well, first, let me just say thank you for the invitation, and I'm honored to join Commissioner Reynders and Member of Parliament Cseh. And I think I'm going to say some critical things about the report, as you alluded to there. So let me just preface them by putting in a little context that when I say these things, you should know this is coming from a huge supporter of European integration. Like you said, I'm a Jean Monnet chair. Really dedicated myself to studying the EU. And I also have the deepest respect for the Commission officials who worked on this report. I think those of us who follow these issues know that Commissioner Reynders is a real ally in the fight to defend rule of law. And look, there's lots of great research that went into the report by the kind of career officials that worked on this. Many important issues, are identified. I thought in particular on media and corruption, I thought those sections in particular were stronger. And, in the long term, in 10, 20 years from now, after this has become an annual sort of tradition, maybe we'll be very glad that it was started and that will have beneficial effects down the line. That being said, right, if we look today, right, for now, this report does nothing to stop the systemic assault on the rule of law that we're seeing that Katalin Cseh mentioned in some member states, and the systemic assault on democracy itself. And I guess I just want to talk briefly about sort of 4 problems I saw in the report, things that maybe could be improved, and just concerns. I mean, first, despite the strengths and some of the findings in the report, the report overall doesn't recognize at any point really the systemic or systematic rule of law backsliding that we are witnessing. Commissioner Reynders mentioned that in his comments, that some member states have a more systematic phenomena going on, but I didn't think that was really reflected in the report. In a sense, the report does identify individual problematic developments, but it doesn't connect the dots and kind of call a spade a spade. You won't see any mention, as Katalin Cseh mentioned, of that one member state is already categorized as an autocracy. You won't see mention that there's really a very carefully engineered attack on the rule of law going on from some governments, which is different than just having individual problems in some other states. Second point, which is related to the first, I do think the report used language that was too euphemistic. Now, I understand you have to be diplomatic in maybe the world of politics in Brussels. I'm across the Atlantic, one of your friends over here. I don't have to worry about diplomacy, so I can just say things. But when the report talks about risks and concerns and controversial reforms, when you're talking about the rule of law being totally attacked, ECJ rulings being flouted, and a government just trying to install autocracy, that's too soft. Third point, this is maybe one of the big meta point, the whole strategy I really have to question, I'll admit. Commissioner Reynders talked about the importance of looking at all 27, and yeah, maybe in the long term that's useful, but I think that strategy was partly adopted as a way to counter the argument from some governments that you're applying double standards to us, the governments of Poland and Hungary particularly, or this, what they call whataboutism, like when they're critiqued, they say, oh, but there's something in another state that's similar. But I don't think looking at all 27 in this systematic way, even if it's interesting, right, and useful long-term, it does not effectively counter whataboutism or the double standard claim. In fact, you saw that the way governments reacted to Commissioner Jourova by, it was disgusting, declare her persona non grata, call for her being fired, et cetera. So that just is proof that you can't engage in constructive dialogue and say we're going to treat everyone equally when you're dealing with regimes that are either autocratic or trying to become autocratic, because they don't engage in sincere cooperation and dialogue. It's basically you're bringing a legal pad and a report to a political street fight, if we're honest, okay? And that's the imbalance, okay? And then the final point, and I hope I didn't go on too long, is just, I guess the one worry I have also politically or in terms of strategy is just about the opportunity costs. People had high expectations of this report. People were waiting. I'm glad to hear Commissioner Reynders say it doesn't take away from the use of other tools, right? Which I think is important. But I just think, yeah, it's, as Katalin Cseh said, it's really vital that the Commission, even if it's doing these reports, doesn't divert too much resources away from things like accelerating and bringing more infringements, accelerating them, requesting interim measures, which frankly they should have done on the CEU case, because it's too late now, requesting penalty payments, right, in cases of non-compliance with ECJ rulings. So I think using the existing tools with more rigor, I think, is ultimately more important than developing new tools. And I'll stop there because I've gone on too long.
Thank you very much, Professor. Since we only have 15 minutes and about 14 questions from our participants still pending, I suggest that we delve straight into the discussion. And then you can also use the time for responding to these questions to react to the other panelists. I don't want to leave anyone out, but I'm afraid that I will have to make some choices. I'll try to couple things a little bit. So let's take, for example, the subject of the of connecting the money to the rule of law conditionality. So we have a question from Sebastian Platten. The German presidency of the Council has watered down the Commission's proposal for a rule of law budget conditionality to the point of making it mostly toothless. Due to the requirement of a direct affectation of the budget, the abandon of reverse majority, and the possibility for the state concerned to stall the suspension procedure for up to 3 months. The main group leaders at the European Parliament are very critical of it. And if I may add, they also came out with an op-ed today to reinforce that position. What is the stance of the European Commission in this regard? And if I can add to that, because there were some linked questions, there was a question inquiring of how do you deal with countries that are not dependent on money from the EU, and yet they have problems with the rule of law. I'm afraid I don't know exactly who's asked that question now. It's Maurice Malt from Olaf. How do we prevent or fight back against disrespect for Article 2 values by countries that aren't dependent on EU money? There you go. At least we're touching on the topic, even if I don't do justice to all of the questions linked to this. Who would like to start?
Maybe if I may, very briefly, because I want to give us some comments on the Professor Kelemen, because first, the opportunity of the report, we discuss on the budgetary situation of the member states and the structural reforms, the Maastricht criteria, since some decades, and more since the bank crisis and the sovereign debt crisis. It was impossible during many years to discuss about the values in the Article 2. So it's very opportune to try to start. And again, I've tried with order to start it since 2016. And now that we have the first report, it's important to show that it's the beginning of a process. The second element, we are not diplomatic, we are factual. And we don't want to give some qualification without real facts and figures. And it's a factual report. And thanks for the positive comments about the civil servants we've organized that. Why the 27? Of course, there are more systemic, I will say that, and systematic breaches. But it's very important to discuss in all the member states about the possible breaches to the rule of law. Of course, with many member states, it will be possible to engage a real dialogue and to improve the situation. But it's very important to do that. There are problems in many member states about the rule of law, and we need to engage with all, and not just with the usual suspects that we have all in our mind. And then, to answer to the question also from the audience, of course, we want to do more if there is a systemic or a systematic breach to the rule of law, or a general violation of the rule of law. We have the Article 7, but we are knowing the limits of the procedure. There's an effect, it's a real pressure, but the rules are very difficult to manage. We have infringement proceedings, and we are using, and will continue in the next weeks and months to use the infringement proceedings. But again, we want to go to the court with a robust dossier with solid arguments, and you have seen again this morning that it's possible to have positive reaction. But of course, it's better to have a new instrument. And is it difficult to live with the position of the Council? It's not the position of Germany. I want just to say that because I had yesterday a discussion with Michael Roth. It's the position of the Council. So Germany, for the moment, share the Council. So Germany needs to come with the consensus or the majority of the Council. But the Council is coming with its views. We have the views of the Parliament, but we have a sort of proposal of the Commission from 2018 with a reverse qualified majority, with a real very large scope. And so we want to start the trilogue, and we want to see if it's possible to have a real discussion between the co-legislators. And we will see at the end if it's possible to follow the proposal of the Commission and the remarks and the op-ed of this morning from the different leaders in the Parliament, or if we are going more to the Parliament. But it will be a discussion between the co-legislator, the Council, and the European Parliament. And of course, all the member states receive money from the European Union. So it's not true that there are some countries without any dependence to the European Union. Of course, there are some net contributors and others. But if it's possible to suspend some financing, it's also a problem for different member states having a netter situation. And so, of course, we will continue to work on it for all the member states, not just for some that we are doing that. And I want just to add that, of course, in such a discussion, we need to take care of the beneficiaries. I've seen that there's some question about that, because if we have a breach of the rule of law in one member state and we suspend some funding, some financing of different policies, it's not against some beneficiaries. To give an example, if we suspend some financing due to a breach of the rule of law in agricultural policy, it's not against the farmers. We don't want to be against the farmers. So we need to find a way to have maybe a direct financing coming from the EU, and we have some proposals at the Commission level to do that. For the rest, we spoke about OLAF. Of course, there are other kind of mechanisms to fight against frauds, abuses, or conflict of interest. We have OLAF, but we will have also at the end of the year, beginning of next year, the new European Public Prosecutor Office. It will be for the first time possible to launch investigations and maybe prosecutions from the European level against different situations in the member states. So to fight against corruption, to be concrete, it will be very efficient.
Thank you. Ms. Cseh, would you like to add something, or? Okay.
Yes, if possible, just very briefly. So let's start with the first question about the Commission's proposal. And here, let me just highlight one thing. So if I read the press nowadays, I read statements from governments saying that the Parliament is so slow, we are preventing European citizens to get money. And let me just say one thing. The Parliament is fine with the Commission's proposal. We are completely okay with that. Who has the problem is the Council. So the ball is at their court and not ours. We are completely happy with what Mr. Reynders just described. So they should get their act together and not us. We are just being consistent. When I got elected in 2019, I became the shadow rapporteur, so-called like the Parliament's representative on the rule of law conditionality file, or like law proposal. It was 1.5 years ago. Nothing happened with it because the Council blocked it. It came back on the table like 2 weeks ago. And they are telling the Parliament that we waste time. I think that's a bit problematic. And there is one more thing that I need to say it very loud and clear, that we are talking about an unprecedented amount of EU public money going into the circulation starting very soon. So when we first started to discuss rule of law conditionality, it was only the budget, which is also a big number. But now we have 700 billion euros that will be spread out with very lax conditionalities so that the countries who are ravaged by the pandemic, they can use it freely. But if we don't tie it to strict rule of law and anti-corruption conditionality, then we are just like burning through the money of European taxpayers. So that's why it's more important than ever before to have this conditionality. And this also comes to the second question. Every country receives funds, and that's fine, because we would like to make it as an equal process and everybody can get something out of the EU, not only to pay in. This next generation EU plan is really a historic achievement, and it's working for everybody. However, we should have the common rules everybody has to adhere to as well. This is a bit coming back to the comments about why do we monitor 27 member states. And I think it's important to have a follow-up, because the nature of backsliding is that it's slow. And of course, we know that we have problems in certain countries. But for instance, okay, let's look at Slovenia, for instance. Last year, probably Slovenia would be a quite happy place. Now look at what happens regarding the media in Slovenia after a change of government. It is not really a happy place. So it's quite hard to spot when these changes happen. I close here because I really interested in the opinion of Professor Kelemen. But one last thing. Final beneficiaries protection is really key. And I think the Commission should elaborate more on what they mean under it. we believe with the parliament, with our group, that we have to have a smart conditionality system about monitoring, freezing in case of breach, and redirecting through the commission for the money to reach the final beneficiaries. This is very important. Thank you.
Thank you. By the way, given that you mentioned how slowly this erosion of democratic conditionality occurs, and the fact that we already are facing serious breaches and serious problems in several member states, not just the usual suspect, then I think the question of an anonymous, which we can pick in the second and final round of responses, this person says the rule of law reports are supposed to be a preventive tool. What does that mean in practice? So that's maybe for the commission, but I still want to give Professor Kelemen the opportunity to respond to the first round of questions that we had, if he wants to, if he wishes to do so.
Yeah, if I could, and I'll be very brief, but yeah, just since the rule of law conditionality was brought up, which I didn't address in my comments, and that goes, of course, beyond the report, but since we're discussing it, I would just say, yeah, adopting that regulation will be crucial. Without rule of law conditionality, of course, the EU inadvertently, continues to fund these autocratic regimes and helps them sustain their kind of clientelistic networks. And so it actually helps entrench them. So it has to be addressed. Now, two just comments on it. Of course, the regulation only needs to be adopted, the 2018 proposal, by qualified majority vote, ordinary legislative procedure. But I think something worrying is going on because the German presidency, seems to be linking this to the MFF in a way, kind of pretending like it needs unanimity. It does not need unanimity. And if it's linked that way, then it's dead, because anything that some of these regimes will agree to will be toothless. So I think there needs to be an insistence on that. And I guess the very last thing, there's a danger, because if a very weak version of the rule of law conditionality regulation somehow gets passed, then I think the toolkit becomes weaker. Because as Katalin Cseh alluded to, under the previous common provisions regulation of the structural funds, I have argued before, you could have suspended funds. I pushed the commission to do that, to suspend funds because of generalized deficiencies in rule of law. But in the new version, they've taken that out. And they're saying anything to do with general rule of law problems is in the separate regulation, right? It's not part of the common provisions regulation. So if you get a bad rule of law regulation, things end up worse.
Thank you. We have only 5 minutes available, but one issue that for me is interesting, and maybe, we want to reflect on is something that, again, an anonymous attendee raises, and has to do with the objectivity of the rule of law. So apparently, Ms. Cseh said that the rule of law is objective, but is it, this person is asking, or is it the breach of the rule of law and I know it when I see it kind of phenomena? But if it is so, isn't it inherently political? Maybe 8 sane adults out of 10 would agree that rule of law is breached in Hungary and Poland, but then it is a political majority opinion. What would be the objective yardstick? Politico, for example, counted the word concern more in other countries' section in the report than in Hungary or Poland. So the number of concerns doesn't cut it, does it? And I'd like to couple this with another question from Victoria Palotay, who's saying, if you involve the European Parliament in the process, how do you make sure that the checks on the rule of law remain objective and not politically biased? Shall we touch on that issue very quickly, 2 minutes each? We're gonna go a bit over time, but I think our audience is interested and will stay with us. Maybe I will start from Ms. Cseh now, because we put the Parliament on the spot.
Okay, so 2 things. First, objectivity. And that's why I think the reverse qualified majority is of key importance, because if we have this mechanism, then the Commission, the guardian of the treaties, makes a decision. And I mean, it would be inherently wrong if I, a Hungarian opposition MEP, would address the acts of the Hungarian government, even though I would have a lot to say, but probably these kind of judgments should be placed in the hands of the experts of the Commission and also the independent expert panel. And we should not water it down the process enough that it becomes a matter of political dealing in the Council. Because let's face it, the Council is just a sinkhole of difficult decisions, of the rule of law, of conditionality, of migration, the cap, you name it, everything just like dies there. Sorry, this is too important for this. It is an expert decision. And well, we had the Copenhagen criteria. Our enlargement commissioner has just proposed a new rule of law criteria for accession countries. He is from the same country where the justice minister argues that the rule of law cannot be measured. I would encourage Minister Varga from Hungary to talk sometimes to Commissioner Várhelyi from the same country who has the methodology delivered himself to the parliament. So of course it's a bit more there can be a process for it. And we have used it in the past and we can use it in the future. I think I replied.
All right. I think that's good enough. Professor Kelemen, would you care to go next, just to reverse a bit the order?
Sure, I'll just be very brief. Look, the principle or the concept of rule of law is very well defined. In fact, in the report, there's a very clear exposition of the definition. It's established in the case law of the ECJ. It's established by the Council of Europe. So really, people who dispute the concept or say it's not objective, that's a strategy of those who want to violate the rule of law just to call it into question. I think we can just ignore that kind of line of argument. Now, in terms of measuring and defining, of course, there's different approaches to measurement, and it's can be challenging to put a number on it exactly. That being said, lots of ratings bodies, World Justice Project, VDEM, they do like score countries on things like rule of law. So it's not impossible, no.
Thank you. Last but certainly not least, Commissioner, you have the final words.
No, but just I don't want to repeat what I said by Professor Kelemen. We have the same reaction on the objectivity. We have described the situation in the report with a real correct reaction of all the member states during the discussions, because we have the treaties, but we have also the case law of the European Court of Justice, the European Court for Human Rights, the Council of Europe take a lot of decisions. And so we have a real set of rules. And it was very important to show that we have some standards about the debate of justice and the fight against corruption and media freedom. And then we see what are the situations in the different member states. So it's very clear. Second element, you spoke about the preventive tool. Of course, it's an early warning for some member states, and it's better to start earlier in the discussions to change the course of the things in some issues. And it's very efficient. We have organized that more and more with the European semester, to be concrete, about the budgetary situation and structural reform. And then, of course, it's very important to pay attention to the conditionality now, because it's true. Katalin Cseh said we will spend more money faster and with more flexibility. So there is a high risk of corruption and fraud and so on. So that's for the EPPO and for the OLAF. But it's also important to explain to the taxpayers in many member states that if we want to have a real solidarity, is to give money to member states sharing the same values. And that's very important. But the main discussion will be about the scope, it's true, but certainly about the rules, the procedure, and the majority. And you know that is one of the most sensitive issues. It was very difficult to come from unanimity to qualified majority. In some fields, for the macroeconomic policy, it was possible to have the reverse qualified majority. But to give an example, about the fine policy, till now, it's very difficult to use the qualified majority. It's possible in the treaties and in some cases, but the member states prefer to discuss with unanimity or at least a consensus at the council level. So I'm sure that we will have a difficult discussion about the reverse qualified majority again, because the majority, it's a signal, I want to conclude with that, of a trust. The rule of law is the problem of the trust. Is it possible to have real trust between the member states, the citizens, the businesses in the European Union? If you want to have an internal market, you need to have trust in the different member states. If you want to invest in another member state, you need to be sure that you have the possibility to go to independent justice if you have a problem. Among the judges, it's the same. We see with the open arrest warrant for the moment. It's difficult to surrender some people from one country to another one if you don't have the confidence in the functioning of the justice system in another country. But the majority is the same. To use the qualified majority and certainly the reverse qualified majority, you need to build a certain level of trust. That means if I'm in the minority, I agree with the decision because I have full trust in the functioning of the EU. And that's the problem that we have for the moment. So we'll discuss again that. It was fine to come from unanimity to qualified majority. I'm sure that it's more efficient to work with reverse qualified majority, like in the macroeconomic policy for the values, for the rule of law. But again, to do that, you need to have a real trust in the system. And it's the reason why it's very important to express the fact that we have an objective report with objective criteria, and the Commission is working on an equal footing on all the member states with the same methodology, with the same principles, and with the same rules. It's possible to convince of that. It will be possible to have a real trust and to go further with an efficient mechanism. But we need to have an efficient mechanism. And again, it will be a discussion between the co-legislators with the Commission in the next weeks, I'm sure.
Right. Well, we have exhausted the time that we had available. I want to thank you very much for your responses, for your interventions, and for this dynamic conversation that we had. Also to our public for being so active and sending us so many questions. Unfortunately, we couldn't touch on everything, but this is just the beginning of this very important conversation, which we will continue. So I look forward to discussing about this topic in future at our next events. Thank you very much. Have a wonderful evening, everyone. Bye-bye.
Bye-bye.